Okay, this week we're going to start Chapter 9. As you notice that we're now into the criminal part of our criminal law class. These chapters to me are extremely interesting. So for this week, you will have your lecture that covers the Chapter 9. In addition, we'll talk over the Blue Book on Chapters 11 and 12. You're going to want to go through your vocabulary. Your Chapter 9 test is going to cover all of these. I've also included a copy of the current Missouri Constitution, and then here's your notes as far as your PowerPoint. I've turned that into a PDF, so if you want to go back and review, this will make it just a little bit easier. Okay, so Chapter 9, we're talking about offenses against public order. In this day and age, this is very relevant information based off what we're seeing in our national media. So again, Blue Book will be covering Chapters 11 and Chapter 12. All of it's going to be testable material. You do have your vocabulary that is on your Blackboard site, and you're going to want to read through all of those, but we'll cover them as we go through this lecture. So first thing we're going to talk about is the First Amendment. Definitely going to be something that we're going to deal with, and like we've talked about before, we have some basic amendments that we work with in criminal justice. Definitely the 4th with search and seizure, 5th with self-incrimination, due process, 6th with the courts, 8th cruel and unusual punishment, and the 14th that applies those back to the states. But sometimes we forget about the First Amendment and how that applies, and as those that may be going into law enforcement or those that may be on the attorney side, this is going to be something that we're going to think about as we go through our career. So First Amendment, Congress shall make no law respecting an establishment of religion, so no state religion, prohibiting the free exercise thereof, abridging the freedom of speech or the press and the right to people peacefully assemble and petition the government. So oftentimes you're going to see stories and you're going to wonder, well, how can people do that? And a lot of times it's going to fall back on the First Amendment. So Missouri Constitution, often we forget about the state constitutions, so we just look at the federal side, but each state has its own constitution. And so this is Missouri's constitution. No law shall be passed impairing the freedom of speech, no matter by what means communicated. And that makes a big difference right here. Every person shall be free to say, write, or publish, or otherwise communicate whatever he will on any subject, being responsible for all abuses of that liberty. So we're talking about libel and slander, and that all suits and prosecution for libel, slander, the truth thereof may be given in evidence, and suits prosecution for libel. Basically, we're looking at the First Amendment, but it goes a little bit different order when we start looking at our state constitutions. So here is a link to you that you can find that. I'll let you go to that on your own when you go to your PDF. So the First Amendment protects the freedom of religion, speech, free assembly, press, petition the government for redress of grievances. So we're having protests and everything that have gone on for several years, depending on what topic comes up. And often, as law enforcement, we're going to run into issues of, okay, when does that line cross from, a First Amendment protected to where we're running into now we've got some criminal activity, and when do we step in and actually enforce the laws? So what we start looking at is the right of people to exercise their First Amendment freedoms, but also the need for public order, personal and property rights of other people. And that definitely is a balancing act that we have to start thinking of. And again, emotions aren't the greatest thing to start using when we get into this type of situation. We need to understand the First Amendment, understand the laws, and fall back on those, or get some advice from our local prosecutor's office or those that are very familiar with the laws, so that we don't cross that line and end up violating somebody's First Amendment rights and get ourselves into a situation where we've caused more trouble than we've actually solved. So free speech in the Bill of Rights. When we start looking at the statutes, some kinds of speech are not protected by the First Amendment and may be subject to criminal laws. Laws directed at the content of speech are subject to strict scrutiny, so meaning that the government must have a compelling interest in achieving some goal. Certain speech people can say, and there's really nothing that you're going to be able to do about it, especially if you're in law enforcement. We'll talk about this in a few more minutes, but that you may have comments directed at you that are definitely going to be not the best. And in a lot of situations, there's really nothing that you can do about that. So we see the officers on these protest lines and they're being yelled at and screamed at, very derogatory. In and of itself, the people doing that are not necessarily committing any criminal acts because of the position that the person in law enforcement is now acting as a government official representing the government, and they're not an individual person. It was told to me many years ago that, if that happens, you are representing the government at that point, and you as an individual do not necessarily matter as much. And if you can't handle that situation, maybe it isn't the job for you. So that may be something that, it definitely made me think of how I would handle that. So keeping our emotions in check, planning, thinking about how we're going to handle those type of situations before we get into them. So things that aren't protected: obscenity, fighting words, things that are, going to trigger immediate physical response, inciting or urging unlawful conduct, defamation, and public nuisances. So when we start looking at, when does speech become a threat, the court's going to look at that clear and present danger test, the test used to judge government restrictions on speech. So it creates an immediate threat of harm to another and may be suppressed by criminal law. So shouting "there's a bomb on a plane" during a flight can be made a crime. Basically, people can get hurt if you say something to that effect. And like we've talked about in previous chapters, this is actually a violation of federal law. Fighting words are words likely to incite, again, immediate breach of the peace and may be suppressed. So fighting words differ from ordinary rude language. They carry the possibility of inciting another to violence. If you were looking at Chapter 11 in your blue book, you can read peace disturbance. So a person commits the offense of peace disturbance if they unreasonably and knowingly disturb or alarm another person by offensive language dressed in a face-to-face manner to a specific individual, uttered under circumstances which are likely to produce an immediate violent response from a reasonable recipient. So fighting words. So it's definitely listed in our statute, and in statutes in different states, it will be there in some form or fashion, though the wording may be just a little bit different. It's talking about the exact same thing. Am I saying something to somebody that is going to make them lash out at me? So they're not going to be thinking about it. It's just going to be a response. So that's what we start looking at when we talk about fighting words. Again, directed at the content of speech, subject to strict scrutiny when we start looking at how much that we control that. Like we talked about just a minute ago when we were looking at Chapter 11 in our blue book, if you are a law enforcement officer or a government official, in certain cases, peace disturbance is going to be one of those things that allegedly you can't have your peace disturbed. Now, is it physically possible to make you upset? Yes. But your reaction is going to be controlled based upon your duties that you have accepted. And when you took the job, you've said that I'm going to accept and be able to deal with this. Some people can, some people can't. So obscenity. When we start looking at obscenity, it's actually in our chapter 16 of the blue book, which we're not covering in this lecture. But if you want to look at it, you can go to that chapter. But obscenity, when identified by state, can be punished as a crime. Defined obscenity, however, has been subject to many court rulings as far as what we look at, what's obscene, what's artistic. It's definitely going to be something that the courts are going to debate back and forth. So, in general, freedom to use obscenity is not protected by the First Amendment when the communication described is in an offensive manner that depicts explicit sexual acts, betrays sexual conduct in a patently offensive way, and the communication has no redeeming social value. And you'll see that, these almost exact words, when you start reading our statutes. So I'll leave this link here and let you go to it on your own. Inciting unlawful conduct, speech intended to produce unlawful actions, is not protected. And again, this is, some of the issues that we have been exposed to if you are paying attention to the national news. One of the things that I do want you to look at is the level of criminal activity when we start getting into those. In your blue book, when you read about rioting, knowing the assembles with 6 or more persons and agrees with such person to violate any of the criminal laws of the state of the United States with force or violence, does violate any of the said laws with force or violence will still so assemble. But if you look at it, it's only a Class A misdemeanor. Refusal to disperse is a Class C misdemeanor, and unlawful assembly is a Class B misdemeanor. So as far as our state statutes, when we're looking at those specific ones, are only misdemeanors. Now, when promoting civil disorder in the first degree, it can be a Class D felony, but a defendant is guilty of promoting that, teaches or demonstrates to any other person the use, application, or construction of any firearm, explosive, or incendiary device, knowing or intending that the firearm, explosive, or incendiary device be used in the furtherance of civil disorder. So this one right here, when we look at it, the person is actually teaching somebody how to cause physical injury. It's not a crime to teach somebody, how to fix a firearm, how to make a firearm, if they're going to use that for legitimate purposes. But the second we cross the line and we're teaching them how to use it to hurt other people, that's where we get into this promoting civil disorder in the first degree. Making terroristic threats in the first degree, terrorist threats second degree, and making terrorist threat third degree. You'll go through all of these as you read through your chapters 11 and 12 in your blue book. So inciting unlawful conduct must be more than mere discussion of violence, making a statement to follow gang members to attack rival gangs, calling a meeting of gang members and making speech urging an attack on a rival gang is inciting. So, what if a man stands on a corner of your house and speaks in a loud voice about the merits of the KKK? Is this protected speech? It's going to depend. How loud is he? Whose property is it on? And, is the corner of your house on a street where they're on a sidewalk? You're going to have to be cautious if you're the law enforcement officer that gets called to that. And, what is the person talking about? Just because you personally take something offensive does not mean it's necessarily a violation of law. And that's where we can get in trouble, in that you go to a call and you agree with one party based on your own morals, and you make a decision to arrest, to not arrest, to ask somebody to move. And now you're getting into that gray area or even a red area where you've crossed the line, and now you're violating the person's civil rights more out of emotion than out of knowledge. So if in doubt, call someone, get your questions answered before you take any steps. And if you do call and you get clarification from whoever your legal body is, be it the prosecutor's office, somebody that represents your department or city, then you want to document that in the report, that you called and you made a good faith effort to cover yourself as far as that goes. So public nuisance laws, I tend to ensure public safety. So loud noise, nuisance speech, riots, we've talked about those and you're going to read them. Again, that clear and present danger, the test used to judge government restrictions, like we talked about before, shouting bomb on a plane. Fighting words, likely to incite an immediate response. Usually different than ordinary rude language because they carry the possibility of inciting another to violence. This right here can get confusing because, I've seen it on calls myself where people are out in the street. Most of the ones I dealt with were impaired, and you're yelling at each other some pretty horrendous things that you would take as fighting words in some situations. But if there's any distance in between them, are they fighting words or is it just rude? And how far away are they? What exactly they're saying? What is their intent? So, the defendant addressed very insulting, abusive language face to face, causing a likelihood the person addressed will make an immediate violent response. If the charge is public order, then the statute ordinance would require a showing that the offense occurred in a public place. One thing that we do have in Missouri is we have private peace disturbance and public peace disturbance when you start reading through those statutes. So law enforcement, like we've talked about before, there are certain times that we can take some action. So if it's a direct threat to the safety of an officer, when a crowd is present and the speech is likely to incite the crowd to violence, and speech obstruction hinders police in the performance of their duty. We have to be cautious. This is where we read up and we look at the current case laws and get decisions from those that are going to handle that case if it goes to court. A couple cases, the defendant disobeys a no parking notice from an African American police officer. The person uses, very offensive language and is arrested, and that was upheld. So when the police officer approaches, he tells the officer, again, some more offensive language and convicted of peace disturbance. That one was upheld. Some that weren't upheld, this right here, the officer runs a license check on a car. The individual and the officer exchange words. Basically, the officer makes an arrest in that case. A term that I heard years ago in some earlier training is contempt of cop, and you don't want that to ever happen. Basically, the officer feels like their authority is being challenged and they make a decision more out of ego than anything else. I will tell you that law enforcement is one of those fields that you want to leave your ego at home. You're going to have offensive language addressed to you. You're going to have issues that in normal situations would make a normal person angry, and you can't do that. So that conviction was overturned. When we started to look at obscene communication, obscenity is not protected in the First Amendment. So obscenity has been the subject of many court rulings. When we start looking at communication that the average person uses contemporary community standards, and you want to really look at this, what are contemporary community standards? Would find appeals to the prurient. So prurient, another word for that is lustful interests or depicts sexual conduct in a patently offensive manner taken as a whole. Again, what is, artistic, what is literary, what's political, scientific value? Those are decisions that, courts sometimes have a hard time making. Inciting, so defense of inciting, and we looked at those in chapter 11 as far as what people do in our unlawful assembly, rioting, refusal to disperse. Definitely you're going to want to read the statutes. What does the statute say based on what the person is doing? So defamation is the offense of injuring the character or reputation of another person by oral written communication. So I want you to remember, libel is written offense, slander is an oral offense, and that is a hint that you're going to want to remember the definition between libel and slander. Civil remedies, in most cases, basically you're going to file a lawsuit against the person versus the government becoming involved and prosecuting. So symbolic speech, nonverbal expression that conveys a belief or idea. Actions that have a purpose other, beyond communication. So wearing a ninja mask to frighten people into leaving city council meeting is not protected. Wearing a ninja mask is a way to protect actions taken by city council meeting. Definitely one of those situations where somebody came in and made a decision to do something, and is it symbolic, or is it disruptive? We have to start looking at that. Past year, states had statutes that made burning or, defilement of the American flag a crime. In Texas v. Johnson, they said no, especially if the person owns the flag. Where we come into issues is Missouri has a statute called flag desecration, and it's RSMO 578.095, Chapter 19 of your Blue Book. And that statute read, a person commits the offense of flag desecration if they purposely, publicly mutilate, defaces, defiles, tramples upon, or otherwise desecrates the national flag of the United States or the state flag of the state of Missouri. But then it immediately starts talking about, in 2014, the United States Court of Appeals, 8th Circuit agreed that this section is overbroad and facially unconstitutional. So we actually have a statute in your book that you can look at that says, hey, we're going to say this is a crime, but the courts are going to say you can't prosecute under it. So definitely one of the things that we have to look at. So cross burning can be a symbolic act. When we start looking at the statute, it falls under 574 period 140, cross burning. A person commits the offense of cross burning if he or she burns or causes to be burned a cross with a purpose to frighten, intimidate, or cause emotional distress to any person or group. The offense of cross burning, again, Class A misdemeanor unless the person has been previously found guilty. So when we start looking at statute, we do have that statute. But can you burn a cross? Yes, as long as you don't have the purpose to frighten, intimidate, or cause emotional distress to any other person or group. When we look at the rest of Chapter 574, this is where we get into our peace disturbance, private peace disturbance, disturbing a house of worship, the ones we've talked about before as far as unlawful assembly, rioting, refusal to disperse. But some other ones that we look at is, in addition to the cross burning, the unlawful funeral protests. And this is an issue that we had a few years back. We haven't seen it as much lately. But when looking at that statute, a person commits the offense of unlawful funeral protest if they picket or engage in other protest activities within 300 feet of a residence, cemetery, funeral home, church, synagogue, or other establishment during or within 1 hour before or after the funeral. So it's definitely, we've looked at this statute as far as the state goes, and they've enacted this. So this, what we talked about just a second ago, the unlawful funeral protest. When we look at a crime, is it a true threat? So true threat is a serious expression of intent to inflict bodily harm. Again, it's not going to be protected. So, I threaten to assault somebody in a face-to-face manner. We're within arm's distance. Definitely going to be a true threat. I call somebody and threaten them. Not so much. I can't actually do anything. So true threats against public officials, school children against teachers, especially in our day and age where we have, the national news talking about our school shootings and stuff like that, terroristic threats, violation of restraining orders, using the mail or telephone can definitely cause some issues when we're looking at the statutes. So bullying, repeated harmful acts which involve physical, verbal, or psychological attacks directed against victims who cannot properly defend themselves because of size or strength. So again, bullying is a crime against persons. When we start looking at that, is it an assault? Is it stalking? Is it harassment? At what level harassment is it? So when we start looking at those, we need to be able to break those down as far as which criminal charge we would use in that case. Now, if you're a school resource officer, you may let the school handle this, just documenting it and let the internal process as far as schools deal with that issue. But at the point that somebody is actually being injured or that emotional distress is going too far, that's where you may step in. So cyberbullying, research has indicated that 1 out of every 5 children ages 10 to 17 receive sexual exploitation advances. 42% are subject to bullying online. Working with high school age children, I do see this. People will come in, so-and-so said this about me. Well, how? Well, they posted it on the internet. Definitely is going to fall under that issue as far as harassment goes, but can we prosecute or not? That's going to be a decision for your legal team that works with you as far as being in law enforcement. So loud noise or nuisance. Supreme Court has stated that it can no longer be doubted that government has a substantial interest in protecting citizens from unwelcome noise. And then here's a link to that case right there. Basically, it was so loud that people just living in the area couldn't comfortably live their own lives. And that's one thing that we look at as far as peace disturbance goes. It's just, you can do what you want to do within reason up to the point it starts crossing the line and it starts damaging the quality of life of another person not involved. So, First Amendment guarantees the right of people to peacefully assemble and to petition the government for redress of grievances. And we can start looking at that. Again, I've provided you a couple links that's very interesting. Obstruction of law enforcement, failure to identify oneself. That's one of the cases that, we see a witness to a felony, so failure to be a witness, that's actually in your blue book. And then making false material statements or providing false information to a law enforcement officer. We would look at as far as false reports, false bomb reports, false missing person reports. There's quite a list when we start looking at those in our blue book. Tampering with a witness, tampering with a victim, giving false information, obstruction, being damage in evidence, failure to identify a known offender, depending on what the statute is. So, public nuisance. Under common law, public nuisance was a civil offense. Today, cities and states continue to use civil law on public nuisance. So let's say we have an area that, we have a large amount of drug dealing and everything in abandoned homes. The court may file and get an order to take over those homes and then, destroy them if they are unlivable, or do something with them where it makes that area where it can't be used for something that is the public nuisance. So, stalking. Serious problem in the United States and Europe. Often stalking involves offenders who have a previous relationship. Having worked many stalking cases, this can be interesting in that some people don't even realize that what they're doing could be criminal. You might have to explain it to them that, hey, you cannot do this, and stalking is more than one incident. So we have to start documenting those. Now, when we look at stalking in our text, it's actually going to fall under Chapter 14. Again, we'll cover that at a later time. But you're going to want to read, what stalking is and how it breaks it up as far as the different degrees. Crime on city streets, anti-cruising laws, truancy arrest or detention, juvenile curfew laws. How late can a person under a certain age, most of the time it's under the age of 18, be out? Laws directed at homeless persons. Again, in stalking. So how a jurisdiction enforces these laws, they have to kind of walk that fine line of, what am I doing? Is it to help the public more, or is it specifically, aimed at an individual? If it's specifically aimed at an individual, we may have issues as far as First Amendment. So, Second Amendment, well-regulated militia being necessary to the security of the free state, the right of the people. You're going to want to remember the people to keep and bear arms shall not be infringed. So, the right to bear arms is an individual right applicable to both federal and state governments. Government may not outlaw complete ownership or possession of firearms, but they can reasonably regulate the ownership or possession. So, licensing laws, restrictions aimed at particular persons, juveniles, convicted felons. We don't want to be providing certain individuals with firearms. Age, drug use, mental status could definitely be something that we would look at as far as a person possessing a firearm. District of Columbia v. Heller, very interesting case, and not that long ago when we start looking at cases. Ban on registering handguns in the home. Keep handguns at home, disassembled or non-functional with trigger lock mechanism violated the Second Amendment. So you're going to want to look at that case. And then the free exercise of religion. First Amendment protects the right to practice of religion. Freedom to believe is absolute freedom. So some violations include handling poisonous snakes, child labor, human and animal sacrifices. Can't do this as far as religion goes. There's been cases on those where, as far as protecting the public outweighs this. Some criminal conduct in the secular setting has been permitted in religious settings. Depending on how you want to look at that and what religion you want to practice, we could have that. Also, the Constitution has, not necessarily specifically said right to privacy, but is implied the concept of personal liberty found in the 14th Amendment, so which applies everything back to the states. Governments may not pass criminal laws that impinge upon the right unless the laws have a reasonable, legitimate government purpose. So when we start looking at, how much can the government invade a person's privacy? Possession of pornography in one's home is not a crime, but reading pornographic magazines public where others could see it. So what one does in their home that doesn't affect anybody else is okay. When we cross the line where it affects the quality of life of other people is where we start running into issues. As far as review, these are links to the chapters that you can go through and start reading those. My suggestion is that you click these and start reviewing your state statutes. One, it's going to tell you what your rights are and where we can cross the line, and get you used to reading that criminal statutes in more than just your blue book. So the blue book doesn't cover every statute listed in here. All right, so next chapter we're going to do is homicide, and that's it for this lesson.